All right, guys, Johnny Depp's brief for his appeal got filed right on time, so we're going to take a look at it. So there are a lot of things to like in Johnny's appeal brief, and we're going to talk about those, but there are also some things that I didn't love. Now, just as a reminder, I am aware that there are eyes on my channel. I just got some kind of cool validation over the last week when Laura Bacov, the real Laura B on Twitter, and Andy Signor from Popcorn Planet went to Johnny Depp's concert. They ended up meeting him backstage, had a conversation with him about the channels that have supported him. And so we learned from that he is aware of the channels out there, including my own. So that was very cool to hear, of course, very validating. And I want to thank Laura B and Andy as well for just very generously sharing those props that they got. That was they didn't have to do that. So that was a very awesome move on their part, and I'm very grateful. So knowing that Johnny Depp has maybe watched my channel means that, probably some other people have as well. And I am not interested in being in a position of potentially influencing the arguments that people are going to make. So I am not at this stage going to do an issue by issue breakdown, legal analysis, point out the strengths and weaknesses of the different positions. I'm going to wait to do that until after the briefs are in. I do have some opinions, however, having gone through it. And so what I am going to give you here, I'm going to give you the 10,000-foot view. I'm going to give you some kind of general overall impressions, and I'm going to go through some of the things that I liked and some of the things that I didn't like. So unfortunately, the 10,000-foot view here is I don't think Johnny is probably going to win this appeal. Now, I say this bearing in mind the person who is appealing is always fighting on the back foot. You've already lost at trial, as the saying goes, appeals are for losers. And so you are at a disadvantage. You typically have a standard that you're going to have to meet to establish an error. It can be more or less difficult depending on the kind of errors that you're raising. I've talked about some of these things with the standards of review in my prior videos on the appeal. He's got good legal issues from a standard of review standpoint. These are pure legal questions, for the most part, for the court to decide. But that doesn't, mean that you are on the winning side of those particular issues. So there are some reasons in this case why I think it's going to be challenging for Johnny to show that he's entitled to a new trial. Now, I do, having said that, think his best chance, in my personal opinion, is going to be on his third assignment of error. And this is the one where he argued that essentially the statement by Adam Waldman is not actionable in defamation because it is clearly an attorney's advocacy. And that makes it much more like an opinion or an interpretation than just a flat assertion of something, based on personal knowledge or whatever. Like, it would be very clear to everybody that Adam Waldman wasn't there, doesn't know these things, and is just making a case based on his interpretation of the evidence that he's seen. This, to me, is a pretty strong argument. And the reason why is because I think there is likely to be a fair amount of hesitation on the part of the court to want to find public statements by attorneys about their cases to be potentially actionable. Now, there is a lot of skepticism in the courts and among the ethical, organizations that produce those types of rules and stuff. There is some skepticism about attorneys litigating their cases in public. And so that is potentially something that is a little bit hard to deal with in this context. So I think you start from the position that the court is not going to be especially friendly to the idea of an attorney conducting interviews on behalf of his client. But at the same time, there is a recognition that yes, attorneys do still have First Amendment rights. Of course, those rights are limited given, the needs of being able to uphold the profession, have fair proceedings and stuff like that. So attorneys are more constrained in what they're allowed to say than, somebody who's maybe not involved in the case. But it doesn't mean that they give up their right to have an opinion or to advocate for their client the best way that they see fit, just because they happen to be involved in the case. And of course, it's very common for attorneys to make public statements about their case. It's certainly not a universal practice. It is something I 100% stayed away from when I was doing a lot of this type of work. But on the other hand, you see, people like Gloria Allred apparently can't even file a lawsuit without, standing on a staircase and giving a press conference somewhere. So these things are not unusual. And knowing that, I just find it unlikely that the court, who is kind of in charge of the cabal of lawyers and legal practice, is going to want to put lawyers potentially at risk for doing something that, although they may not love it, is very common and very predictable as part of representing somebody. So at this point, that's as far as I'm going to go with the substance of the arguments. But let's go ahead and take a look at some of the things that I really liked about this brief and some of the things that I didn't. So first off, this brief reads in Ben Chu's voice. You can practically read this and see him making the presentation from the podium. It sounds like him. And Ben has a good voice for an advocate. He's clear. He is precise. He's very analytical and organized in how he thinks and how he talks. And his brief really reflects that. It is a very organized brief. It is easy to follow from an analytical standpoint. Here's what we're talking about in this place. Here's what we're talking about in this other place. Here's how these arguments tie together. So he's done a very good job of making the structure of what he's getting at in this appeal very clear and very easy to follow. I suspect that most lay people picking up this brief would not have a particularly difficult time understanding what it is he's arguing and why he is claiming that the law is on his side. From a stylistic standpoint, however, I do have to take some issue with what I would call the absence of the storytelling element in this brief. Now, I don't know how much of this is just due to the format. Most briefs have format requirements. You have to include this section that talks about, this thing, specific content that you're required to include that limits your ability to, just say things the way that you would maybe choose to in the absence of that kind of structure. But even within the confines of having to, write a procedural statement of the case, having to specifically identify, where in the record your assignments of error were preserved, that type of thing, there is still a way to do this in a way that communicates to the court why they should care about this, why they need to rule in your client's favor. So we don't get a lot of that in Johnny's brief, in my opinion. And part of that is because while it is extremely well organized, for example, we can see these sections with these headers that break out these different topics that Johnny is going to develop in order to make his argument. But the headers themselves are very boring. They're descriptive, but they don't really grab you with what conclusion am I going to reach after I read this section. They just kind of tell me generally what I'm going to be reading about. And so it reminds me a little bit of kind of like reading a cookbook, where you'll have just a sort of list of ingredients, but you don't necessarily know, how they go together until you get way down into the instructions and sort of start piecing things together. And a cookbook is certainly a very effective piece of writing, but it's not necessarily the most persuasive and compelling piece of writing. There is no rule that appellate briefs have to be compelling. They should be persuasive. But this is just something that I have found as a matter of style, what works and what doesn't work on appeal. Again, judges are human, just like everybody else. They don't want to be bored reading your brief. They want to know, what's the point? What are we doing here? And I did not get a 10,000 foot view, what this case is about and why it matters in, 30 words or less from this brief. So that's a shortcoming from my perspective. It's not a fatal one. It's really just the difference between a brief that, may win, may be good enough, and a brief that is really highly effective at pulling the judges over to your point of view. Something I definitely noticed as an appeal attorney is that Johnny has what's called an issue of first impression. And this means a legal question that the high court in that particular jurisdiction hasn't ruled on before. And so in this particular case, his issue of first impression is whether an attorney engaged in litigation is per se, automatically, an independent contractor of the client rather than an employee. And so this is an important part of his argument because he's arguing this undermines Amber Heard's agency theory and her ability to prove her agency theory in order to attribute Adam Waldman's statements to Johnny Depp. So issues of first impression for appeal lawyers, I mean, these are the holy grail. Like, this is what it's all about. This is why you do appeals. You're in a position to shape how the law develops in your particular state. So this gives you a lot of leeway to be able to play, to develop not just how this law, this legal question has, been technically sorted out in other jurisdictions, but why? What are the reasons why it would go this way versus this other way? Why does it matter? What are the potential consequences of deciding for Amber Heard on this versus deciding for Johnny Depp? And so this is an area as well that I'm just not really sure that they played enough in this area for my liking. They certainly went and did a review of the different jurisdictions that have reached decisions going the direction that Johnny wanted them to, but it doesn't really get into a lot of depth about why and why it's important that in this particular case you should go, with this particular interpretation versus this other one. The court is going to be thinking about these things, so not addressing them in the brief to me does seem a bit like a missed opportunity. Now, we haven't seen any of Amber Heard's briefing yet from her new appeal lawyers, but I am going to predict that we're going to see something stylistically very, very different than we got from Johnny Depp. This is one of those intangible things that can be a little bit hard to explain, but there is a style of appellate writing and appellate advocacy it's just different than what you're dealing with in a trial setting. And so the argument that Ben Chu has developed, organized, laid out in his brief is, as I've said, it's a valid, adequate argument, but stylistically, it still reads like trial advocacy. And what I mean by that in some ways is it's simplifying things down to make them easy to consume, easy to digest. This is a skill, and it's something that, of course, you very much need to be able to do at any level of advocacy. But it's something that tends to be more how you focus on persuading a jury than how you focus on persuading judges. Judges, especially at the appellate level, in some ways, they kind of want to complicate things. That's almost the point, because they're not just dealing with how is this particular dispute in front of me going to come out. They're thinking about, we're making decisions that are going to affect lots and lots and lots of other cases that come before the courts. So we really need to think hard about the downstream implications of the decisions that we're making here. That's the type of thing that really stands out stylistically in appellate advocacy, is this focus on much bigger principles and the reasoning for the principles, much more than, typically the nitty-gritty details of any individual case. So I do expect, frankly, that we're going to see more of that from Amber's attorneys who, by appearances, I won't say they're appeal specialists because they clearly do trial work, but they obviously have a ton of experience with appeals. This isn't new territory for them. And so assuming that that's an arena that they're comfortable with and familiar with, I do expect that reading through her brief, it's going to sound a little bit more high level, a little bit more ivory tower, a little less about this is the details of what happened here, and much more about this is what's going to happen in the future in other cases if you don't adopt these rules the way that we are suggesting that you should. So overall, my takeaway, this brief is a very competent piece of legal work. It gets the job done, certainly. I don't think it's really presented in a way that an appellate specialist would necessarily present this case. But again, that's not necessarily fatal. It's really just a question of style and to some degree preference. So just my interpretation and my thoughts based on how I do things. As far as what's coming up next, we learned from DUI Guy that Amber Heard did get an extension of time in order to file her brief. So she had requested that back in October. Apparently, it was granted over Johnny's objection, but she did get more time, and she's going to be able to file 5 additional pages, more than the 50. She wanted 10 more. The court gave her 5. So she did get permission to file an overlength brief as well. Johnny is going to get more than likely, he's going to get additional space in order to respond. But at this point, that's what we are waiting for, is simply for Amber Heard to file her brief on her issues. At the same time, she's going to have to be working on her response to this particular brief that Johnny has filed. That is supposed to be due 30 days after he filed his brief. So she's got a lot going on right now. Things get backed up. We might see more requests for extension. It's a little bit hard to say, but at this point, the ball is in her court, and that is what we are waiting for. So as soon as we get those documents, I will be taking a look. I will let you know what I think. And again, once all the briefs are out, then I'll start talking way more specifically about my view of the legal issues and where I think some of the strengths and weaknesses are. So stick around, and I will see you in the next one.